Brandon Garrett is a professor of law at the University of Virginia and author of Convicting the Innocent. Can you talk about racial bias? How much is this a case of, how much does this present itself in these wrongful convictions?
Well, we certainly see a big racial disparity in these cases. Many more minorities, mostly Africans and Hispanics, were among these 250 people exonerated by DNA than in the general population of people convicted of rape and murder in this country, which is itself, skewed racially. So there's an even bigger racial skew in these cases. And what was also really interesting was that a lot of these cases involved minority, mostly African American defendants and white victims in rape cases. And I don't know what explains that. It could be that one explanation is simply just the way that rape cases get handled in this country. Maybe prosecutors took those cases more seriously or thought they would play better before a jury. Don't know. Another possibility is that eyewitness memory doesn't function as well when people are making cross-racial identifications. And there have been a lot of studies on this. Some of these people even tried to bring that up in court, to bring in experts to explain to the jury that, look, eyewitness memory, just people have a harder time recognizing folks of the other race. Judges won't let them do that. But it's very disturbing, obviously, and it raises more questions about accuracy of cases outside of these handful of DNA cases that we know about. And we just don't know what's causing this race problem among the innocent. But it's yet another reason why these cases should really, really disturb us.
The United States throws more people in jail than any other country, and there are these problems, as you're describing, systemic problems that go to the core of evidence and testimony. And, you point out in your book, you seem to have an issue with the courts, and you would think that the courts would want to address, as you say, these well-publicized problems, but you say the Supreme Court has chosen not to hear about these issues.
Our criminal justice system is so fragmented. Right, in any state, there may be countless police departments, different local jurisdictions in which prosecutors are elected, local judges, and so with a system that's divided into so many parts, it's really hard for the system to improve itself, even in response to really serious miscarriages of justice. And so some states have tried to pass legislation to improve the way that lineups are done. Sometimes police departments, on a police department by police department basis, have responded and decided to videotape interrogations. But there's no way to get change across jurisdictions unless a state passes a law, and states are reluctant to tell police and prosecutors what to do, or unless the U.S. Supreme Court does it as a matter of constitutional law. The Supreme Court doesn't issue constitutional rulings very often, and it hasn't revisited many of its criminal procedure rulings for decades. And in a lot of these areas, the Supreme Court sort of thinks of eyewitness evidence, confession evidence, forensics, as evidentiary issues for the state courts to handle, not questions of federal importance. And so you have these problems that fester for years and years and years with no one really accepting responsibility for an ongoing problem. I do think there are some grounds for optimism. You do see, I think last year 24 states introduced legislation to reform the way that lineups are done. A lot of the fixes to these problems are really inexpensive. It doesn't cost very much to just do a lineup right and have the person administering it be double-blind and not know who the suspect is and tell the eyewitness that. It doesn't cost very much to just turn on a video recorder and tape an interrogation. It doesn't cost much to have quality control in a forensic lab. You just need to have some random blind auditing to check their casework, just like any other laboratory would do. And so, when you have cheap solutions and really expensive problems, you'd expect there to be just some common sense adoption of them, but just things happen so slowly in criminal justice. And it's starting to happen. I hope it happens more.
What is the argument? Would some people say this makes it harder to convict people who are guilty and puts criminals on the streets? Does that hold any water?
There's some areas where that might hold water and where you're really worried about a trade-off. But here it's hard to see what the trade-off is. In these cases, in more than 40% of these cases, the DNA tests not only freed the innocent, but they identified the actual culprits. And so initially you had courts being hostile to requests for DNA testing. And that made no sense at all because those tests could identify the guilty person, as indeed they often did. And so finally, a decade or so later, you have more and more state laws granting access to DNA testing and a growing recognition that, look, DNA testing is good for finding the guilty and freeing the innocent. But even that took some time. And the same is true for forensics. You can have people who are freed, and indeed, in some of these cases, the guilty initially went free because forensic analysts made mistakes. And so, accurate forensic work certainly helps to identify the guilty, and it can also free the innocent. Same with eyewitness IDs. You have bad lineups often, maybe in a third of the cases from the few archival studies that have been done, where eyewitnesses identify fillers in the lineup. That's a false identification. It doesn't lead to a wrongful conviction usually. Police know that was a filler, a mistake was made. But that damages the credibility of the eyewitness, and the police may not want to go forward with that person if they can't make an identification. And that's the kind of situation where crimes may go unsolved because of poorly constructed lineups. And finally, police departments that have adopted videotaping of interrogations have uniformly said, this is the best thing that ever happened to us because you don't get these frivolous challenges where people say that they were manhandled by the police or they were coerced, and then you review the tape and find out that no, they volunteered the facts and the interrogation was done professionally. So all these changes are the kinds of things that create more accurate evidence that everyone can benefit from. I think it's just inertia and the fragmentation of our system and basically just lack of attention to problems of criminal justice that have let these problems fester for so long.
Let me just ask you before we run out of time, is there a case in particular that really bothers you?
There are so many cases that really bother me. A recent Supreme Court decision from this last term is just the latest, this Connick versus Thompson case that people may have seen reports of in the news, where the Supreme Court said that the prosecutor's office shouldn't be held responsible civilly for repeat violations of Brady where evidence of innocence was kept from the defense. And there, one of the pieces of evidence was a forensic report showing that the defendant didn't have the blood type of the evidence from the crime scene. Powerful evidence of innocence. The prosecutors knowingly withheld it from the defense. An unfair trial resulted. A wrongful conviction resulted. John Thompson, in that case, spent more than a dozen years in prison, including some on death row for a crime he didn't commit. And the Supreme Court says, well, but the office shouldn't be held responsible for not training its prosecutors because they're lawyers. This stuff should be obvious to them, which is just bizarre reasoning. How are you going to have accountability when mistakes do happen, and worse, when misconduct happens, if the office isn't held accountable, and if prosecutors are individually immune, right? Where no one is held accountable later on, and where most violations never get detected. That's the unusual case where it came to light that they had hidden evidence of innocence. If evidence gets hidden, it may stay hidden, and no one may ever know that prosecutorial misconduct occurred. But if there are no repercussions when it is detected, then how can we expect to have an accurate system? So someone needs to be held accountable, and that's why that's just the latest infuriating decision that has come down even since the book was published.
Brandon Garrett, thank you so much for joining us. Brandon Garrett is a professor of law at the University of Virginia and author of Convicting the Innocent.